Hello everyone, I'm Ashani Kankanage. Last time we spoke about marriage under law of persons, and this time we would be talking about divorce, which is quite the opposite. So what is actually divorce? So divorce is the legal mechanism which is established to legally, lawfully terminate the marital union of two parties. So when you take divorce, you don't have much of options. Under Roman Dutch law, you have two grounds for divorce, which is basically adultery and malicious desertion. But when you look into section 19 of the MRO, we can see a new addition to the grounds of divorce, which is actually influenced by the English law, and that is sexual impotency at the time of marriage. So moving on with those three grounds, we'll first move on to the first ground, that is adultery. So when you take the ground of adultery means you are having an extramarital relationship with another party other than your spouse, and it has to include sexual intercourse also. So this has to be actually done willingly by that spouse, and also it is a civil wrong and not a criminal offense. So under adultery, the consequences that you can see, it serves as a ground for divorce, and also the aggrieved spouse can claim damages from the co-defendant. So that is what actually adultery means. So moving on to the cases and all. So the burden of proof when it comes to adultery is on the spouse who alleges it, and when you take the degree of proving, it's very high. And in the case of Genesi versus Genesi, you can properly see that it was held that the degree of proof is actually quite same to the degree of proof that you needed to prove a criminal offense. So in that case, it was held that you need the same degree of proof which is needed like to a criminal offense. And there are a few Sri Lankan cases that you can also refer into when it comes to adultery. That is Jayasinghe versus Jayasinghe, Gunasekara versus Gunasekara, and also there are a few other cases you can look into. Moving on to the next part, which is actually the co-defendant. So when it comes to the case of adultery, the co-defendant or the adulterer has to be named. So under section 598 of the Civil Procedure Code, it properly says that you have to name the co-defendant. And also when it comes to the naming of the co-defendant, now when you name the co-defendant, you can claim damages, and there are two types of damages that you can get from that person. So that can be either sentimental damages, or you can get damages for the loss of consortium, or else, which is also known as the loss of companionship. So when the other spouse is actually committing adultery, you lost the companionship of the spouse, so you can claim damages for that from the co-defendant. So when you are naming the co-defendant, basically you have to remember there are certain exceptions that you can also go on without naming the co-defendant. So these exceptions are: if the co-defendant is dead, you don't have to name the co-defendant, or else if your spouse is leading the life of a prostitute and you don't know who exactly the co-defendant is, you are exempted. And also if the co-defendant, if you have taken an effort to find the co-defendant and you cannot actually find the co-defendant's name, then you will be exempted in front of the court. So section 599 of the Civil Procedure Code goes on to talk about the proceedings. Please refer into that section so that you can know more knowledge on the proceedings. So moving on to the damages and the compensation. In the case of De Silva versus De Silva, it properly says the damages will be compensatory and not punitive. So under this case, damages is actually separated into damages like the actual feelings, the sentimental damage, the marital honor that he lost. So you can claim damages for things like that, and also the actual value of the spouse that you lost. So those are two types that you can gain as damage, that you can claim as damages from the co-defendant. under the case of De Silva versus De Silva. So also you can look into the case of Alice versus Alice, which also you can refer for information for damages and compensation. So when it comes to damages and compensation again, so the court at the end of the hearing can actually ask the co-defendant to pay full or half the amount of the court proceedings, and also plus with the claims that the aggrieved party is asking for. But again, there are exceptions for the co-defendant to not to pay the damages if the co-defendant didn't have the knowledge that this person, she or he is committing adultery, is married, and also if the spouse who has committed adultery has led the life of a prostitute, then that co-defendant will not be entitled to pay those damages and the cost of the court proceedings. So these are the main information or the knowledge that you have to know when it comes to adultery as a ground for divorce. And then we'll move on to the condonation, the concept of condonation. So this concept actually gives the idea of forgiveness. So basically what has to be done is, it has to be proven by the innocent party that he or she is ready to forgive the defendant or the person, the guilty spouse. So in the case of Neiman versus Neiman, it has been held that just giving mere shelter for the guilty spouse is not actually cannot be accepted as condonation. You have to restore the guilty spouse to the position that he was before at the household to actually accept that condonation was given or the condonation was done. So cases like Jayasinghe versus Jayasinghe can also be referred when it comes to the concept of condonation. So when you take this whole idea, it's the idea of giving forgiveness for the guilty party by the innocent party, which actually cannot be just proven by given mere shelter, or just actually taking him inside the house would not do anything good. If you want to prove, yet again, you have to restore him again on his usual marital responsibilities and obligations. So let's move on to the next main ground, which is malicious desertion. This is just not a mere departure. It has to happen at certain circumstances with a certain time length, which properly shows the deserting party does not have the intention to return to the relationship. So we know that cruelty is not a ground for divorce, but under malicious desertion you can actually include cruelty as a ground for divorce. So when you take malicious desertion, there are two types, which is simple and constructive. So under simple malicious desertion, you can properly see that the deserting party does not have the intention to return to. And when it comes to malicious desertion, constructive part, you can properly see that the deserting party was forced and compelled to leave the spouse, and also here the intention for the termination is actually compulsory to be proved, and it is actually a deciding factor. So when under malicious desertion, intention and evidence like facts both has to be proved. And when you take actually malicious desertion, giving up of the marital privileges and duties, in the case of Silva versus Misinola, it properly said that if one party has given up the marital obligations and the privileges, then you don't actually have to have a reasonable cause for the desertion. Just giving up the marital obligations and duties can become a reasonable cause. So moving on, and also if one party who actually deserted first is actually willing to come back, and the other party rejects the coming back of the spouse, then that party becomes the deserter and he will be the deserting party. So let's move on to those two parts, which is simple and constructive. So you just have to basically know what is simple malicious desertion and what is constructive malicious desertion. So when you take simple, that is like you have to have a fixed intention that you are not going to come back to this relationship. And also when it comes to constructive, you were compelled and forced to leave, that you were obliged, you were forced by the other party to leave the matrimonial home. So this is like the difference between simple and constructive, you just need to know. So if you want to get an idea, like if you want to know how it happens in the practical life, go through the case of Herft versus Herft when it comes to simple malicious desertion, and when it comes to constructive malicious desertion, just go through Anulavati versus Gunapala. So when it comes to the case of Muthukumara Swami versus Parameshwari and Neville Fernando versus Chandrani, so these cases would be helpful for you all to know about constructive malicious desertion. And another part is in the case of Somavati versus Alvis, it properly said about an instance where the mother-in-law was actually cruel to the daughter-in-law, and the daughter-in-law was given the chance of malicious desertion because the mother-in-law was actually treating her in a cruel way. So it doesn't have to be the husband, it can be either the husband or some other party who are connected to their life. So to know about these practical aspects and exceptions and certain scenarios, you have to go through the cases which I mentioned, just to know about the factors and just to understand this concept more. Moving on, so there is a Roman Dutch law concept that the right about the wife. When it comes to the wife has the right to stay in the matrimonial home. So under the Roman Dutch law, yet again, the wife has the right to stay at the matrimonial house, and if the husband wants her out of the matrimonial house, then he will have to find her an alternative house and when she is thrown out of the matrimonial home. So when you take a refusal to consummate the marriage, if one spouse is actually refusing to consummate the marriage by sexual intercourse, then that other spouse is actually given the chance for malicious desertion. So Vijayratna versus Vijayratna is a good case for you all to go through and understand this concept. So moving on to the next ground, which is sexual impotency at the time of marriage. So this should be like a fundamental incapacity, like when it comes to the husband, he should be impotent, or the wife should be having a problem of actually procreating children. So this is like a fundamental incapacity, and when it comes to this, you shouldn't have been knowing this fact before the marriage. If you knew about this fact and still you got married, then this won't serve as a ground for divorce. This would only serve as a ground for divorce if you didn't know about this fact. So in the case of Gunatilaka versus Missinona, it properly says if the wife or the husband actually properly disagrees, if they are in a position to get treatment and get better, and if they are actually saying no for the treatment, then the other spouse is actually entitled for a divorce under the ground of sexual impotency at the time of marriage. So this all actually applies yet again if you didn't know about this fact about impotency at the time of marriage. So moving on, if you want to know more about the divorce procedure, if you want to know more information about the procedure, please read section 602 to section 605 of the Civil Procedure Code, which would help you. So let's move on to the doctrines of which comes under the law of divorce. That there are two actually: the fault-based system and the marriage breakdown theory. In Sri Lanka, we have the fault-based system where you have to prove that one party is guilty of a fault. So Sri Lanka has that, and the breakdown theory, you don't have to have actual matrimonial fault. If the matrimonial relationship has died between the two parties, then you can go for a divorce under the breakdown theory of marriage. So in Sri Lanka, we don't have that. So in both concepts, you have pros and cons, but in Sri Lanka, we have the fault-based system. So this is actually the whole concept which comes under the divorce part. So when you take the past paper questions, divorce question is actually a very constant part it does not actually, you can't have a past paper without a divorce question. So remember, even in the very recent past paper, which is the October 2019, the first question was from malicious assertion. So remember, you have to answer the divorce question if you are writing for law of persons paper. So understand this concept and always make sure. Now I mentioned some of the cases which are like actually landmark cases, but I can't be spoon feeding you all about all the cases. But when it comes to law of persons, you can find loads of cases. So when you are writing your answers, support your answer with 3 to 4 cases which under certain concepts. So remember to do some research and find more cases which would actually come up to 3 to 4 cases with certain small facts. You don't have to go into detail, but remember certain facts. So I really hope this help you all to understand the concept of divorce. Let's catch up soon. Thank you so much.